Good evening. Welcome to tonight's meeting of the Commonwealth Club of California. You can find the Commonwealth Club online at commonwealthclub.org, and you can view our videos on YouTube, catch up with us on Facebook, on Twitter. I'm Ed Wasserman, Dean of the Graduate School of Journalism at UC Berkeley, and your moderator for tonight's program. It's my pleasure to introduce our speaker tonight, Floyd Abrams, noted attorney, constitutional law scholar, and author of the new book, The Soul of the First Amendment. Floyd Abrams has built his career around defending and advancing the exceptional protections for expressive freedom we enjoy under the First Amendment. From college campuses to cable news, the First Amendment in recent years has been ever more at the center of heated conflicts across the political and economic spectrum. Events in Charlottesville, Virginia, and across the Bay here in Berkeley have raised questions about how broadly the First Amendment should be applied to expression regarded as hate speech. On the other end of the economic spectrum, court rulings extending free speech protections to corporate players have raised concerns that too much freedom subverts rather than safeguards the marketplace of ideas. In his new book, Floyd Abrams makes the point that American law protects free speech more often, more intensely, and more controversially than anywhere else in the world. He should know. Over nearly a half century, Floyd Abrams has built a career at the pinnacle of America's First Amendment bar. His cases include victories in the Pentagon Papers, in which he was on the side of the angels, and Citizens United, where many of us had our doubts. He is recognized for his outstanding contributions to the advocacy of free speech and has appeared frequently before the U.S. Supreme Court. I should disclose that I had the privilege of being Floyd's client twice. Once as a plaintiff, when we sued a South Florida sheriff for pulling his public notices out of the newspapers I ran to punish them for covering him critically. We won. And a second time, less gloriously, when I was among the defendants in a defamation case, we settled. I will say, though, that working with him and his stupendously talented lawyers was an adventure and a great pleasure, which is why I'm especially glad to serve as his moderator tonight at the Commonwealth Club. Please welcome Floyd Abrams.
Thank you very much, Ed. I've appeared before a number of audiences around the country touting my book. I've never appeared before one which was devoted enough to the cause to cause events like this to happen, just to prepare for my appearance. Who'd have thought that it would all be so relevant? I thought in the limited time that I'd talk before we have an exchange and then an exchange with you, I'd talk about two sorts of things. One which is in a sense more book related, but not just that, is how different are we from other countries in the degree to which we protect the First Amendment. And then number two, what sort of threats seem most pressing at this moment with respect to the First Amendment and in particular, freedom of the press? As for the first, I thought maybe I'd just start out with some examples. Ed mentioned hate speech, which we generally and almost always protect, except in the rarest circumstances. Hate speech, speech directed against people, races, religion, sexual orientation, and the like. Speech which would be illegal throughout Western Europe and Canada, democratic countries that care about free speech, but do not have the level of engagement with it, even devotion to it, maybe over-devotion, depending what you think of it, that we do. To pick a name, Donald Trump's. Some of his speeches during the campaign about Mexicans, Muslims, others, would be criminal throughout most of Western Europe, where speech which is directed at a group of people as a group, denigrating them, attacking them, and the like for their membership in the group, would be and is deemed criminal. And politicians in Europe have been banned for running for office, have been fined, and have been found guilty of criminal conduct for saying, as I'll mention in a moment, things very like what then candidate Trump had to say. But let me start with two cases, one in Canada and one here, which I think flesh out the sort of differences that I think at least are most interesting. In Saskatchewan, Canada, it was announced that high schools were going to teach about homosexuality. A religious zealot, I think it's fair to call him, was appalled by that and printed out flyers which he put in 1,000 mailboxes around Saskatchewan, which basically said they're going to teach buggery, they're going to teach this, they're going to teach that. And he didn't just oppose teaching anything about homosexuality in the high schools, which he did oppose, but he did it in the grossest and most vile way, attacking homosexuality and homosexuals as a way to get his argument across. He was accused of criminal conduct and was convicted in Canada, and that conviction was upheld by the Canadian Supreme Court. They have a First Amendment-like language, sort of like ours, the language at least, sort of like ours. And the conviction was upheld unanimously by their Supreme Court, saying that the denigration of groups not only stigmatizes them, but leads to, and has led to, throughout history, a terrible, not only limitations on them, but ultimately discrimination against them, and in some up to the level of genocide. Compare that case to one that the U.S. Supreme Court decided just a few years ago about the group known as the Westboro Baptist Church. The Westboro Baptist Church is a family, literally a family of 5 or 6 people who go from church to church, basically around the country, when American soldiers who've died in Iraq or Afghanistan are being mourned in a church or other place of worship with signs. They stand only where the police tell them they can stand, as far away as the police tell them to stand. And they have signs denouncing the dead soldiers. And what do the signs say? The signs basically say he deserved to die because, in effect, the U.S. is too soft on gays. The U.S. favors homosexuals. This is God's punishment. That's what the signs say. And they're on the day of the funerals. And you can imagine, inflict enormous psychic harm on the parents and relatives. The father of one of the dead soldiers sued. And he said that this was a legal claim based on the notion of what we call intentional infliction of emotional injury. And the case went all the way to the Supreme Court. And the Supreme Court said, in so many words, you can't have that claim in a case like this. The speech involved here, offensive as it is, related to matters of public interest and public importance, and that is the role of gays in the military, the role of gays in American life, how we should react to, treat, respond to, etc., gay people. And the Supreme Court, in very strong language, not only said we have to allow this speech, but they say this sort of speech is entitled to special protection under the First Amendment. Special because it relates to matters of public interest and public concern, whatever side it said, and however offensive it was. And that's our law on this subject. Now that divide between the US and Canada, no less, is reflected again and again in our relationship to other democratic countries. And bear in mind, I'm not talking about undemocratic. I'm talking about Western Europe, Canada, England, and the like. So in Belgium, a person has a sign saying, "Belgians and Europeans first, stand up against the Islamification of Belgium." Criminal, held to be criminal in Belgium as putting down members of the Islamic faith and having particular impact on, quote, less knowledgeable members of the public. In England, a person with a sign with a picture of the World Trade Center ablaze. And the sign says, "Islam out of Britain. Protect the British people. Don't come over to this country and treat it like your own. Britain first." Held to be criminal speech in violation of their law. Now, that's just one example. Another less pressing, maybe less offensive, Finland. Finland, the country just celebrating, I watched the president of Finland on television today, celebrating their 100th anniversary as a free country, but long before it was free of outside domination. In 1776, the same time Thomas Jefferson was writing you know what, Finland already had a Freedom of Information Act, as did Sweden. And it's a country that has year after year won awards for being the freest country in terms of free press in the world. The Prime Minister of Finland had an affair with a young woman. She wrote a book about it. He sued on privacy grounds. And the government of Finland sued on privacy grounds. The result in Finland was that the book could be published, but not with any of the sexual content that she'd written. Sorry. And not anything about his children and their reactions to her. Can you imagine here a Monica Lewinsky book, which to her great credit, she never wrote. If President Clinton had brought such an action, the mockery would have been one thing, but the notion that the First Amendment would allow the suppression of a book about a woman that had a relationship of that sort with a then president, no less. So that's my example number 2. And number 3, I would say to you something which may be the most important of all. Europe has now adopted, throughout all of Western Europe, something called a right to be forgotten. And the right to be forgotten is basically a rule established by the super court that governs all of Europe, which basically says if something has been published in a newspaper years before, it is personally embarrassing and it is no longer relevant. And pause on the word relevant, but that's the word they use. No longer relevant. And the person complains to Google or another carrier like Google. They have to take it down or go to court and defend themselves. Over 500,000 articles have been taken down, not carried in Google, throughout Europe as a result of such complaints. And in a quite recent case in Belgium, someone who drove a car recklessly leading to the death of 2 people, but 15, 20 years ago, wrote to Google saying, take that down. It has nothing to do with anything. It's all private. It's all over. Google said no. They went to court, and Google lost. And the answer was, it wasn't relevant to anything anymore. Here, we would say, I have no doubt, our courts would say in so many words, we don't keep Google from telling the truth about things. Somebody was in an accident, somebody went into court, there were judicial proceedings, a truthful article was published about it. We don't start down the road of saying, you can't print that anymore, or you can't carry it anymore on Google. So there's a constant pressure on Google and its competitors in Europe to delete material which is not deemed to be relevant anymore, including material about events in court, but some years back, and determined not to be, quote, relevant, unquote. Again, unthinkable here. We don't have such laws. Such a law has been proposed in the New York legislature, which is not going to go anywhere now. But it is, I think, maybe the best example of quite how different the legal systems are, even between systems, which both care about, say they care about, and I think they do care about, principles of freedom of expression, but just a different view as to the urgency of the government not getting involved with freedom of expression at all. I mean, remember, our First Amendment and our Bill of Rights is all and only about limiting the government. It is that and that alone. It is not a promise of free speech of you against your employer or your friends or whatever. That is a protection against the government. And that is the core of what it was about from the start. And it's not coincidence that the First Amendment is couched in terms of Congress shall make no law abridging the freedom of speech or of the press. But that is the direction that we have taken, and it is a direction which has led to significantly more protection for free speech as against the government. Now, bear in mind, the government is broad. The government is the University of California. The government is universities which are state universities. The government isn't just of Sacramento. The government is anything that there may be arguments about it, but some government-owned or run institution or entity. And so that's why we have lawsuits on campuses around the country when speakers are shut down or shut up, because if the government can't do it, a state university can't do it either. So that doesn't give an Ann Coulter, for example, the right to speak at a public university. But it does mean that if the way the university is organized is that student groups can invite a left-wing speaker, the university can't tell them that they can't invite a right-wing speaker, and vice versa. All right, just a few thoughts now before we start our discussion about the big dangers to the First Amendment right now. First, some of the things that had been said by the president are not things which are very dangerous. For example, he said more than once, we ought to change our libel laws. We ought to loosen, he said, our libel laws to make it more possible for him and people like him to bring libel suits. He really said it. And what I don't think he knew, and I suspect he doesn't know, is that we don't have any federal libel law. There is no United States libel law. There's nothing to tighten or to loosen or to unloosen. We have 50 state libel laws, and we have the First Amendment, which governs everything. So what he doesn't like is that because of certain case law, starting in 1964, if a president or any public official brings a libel suit, even about things which aren't true, if the person that wrote them believed them, there can't be any liability. It's a state of mind test. So the president or public official or prominent public figure would have to show not just that what was said wasn't so, which is one element, and not just that it was about the person that sued. Have to show also that the speaker either knew or suspected what he or she was saying wasn't true, and that's very hard to prove. But that's not at risk today. It would take the Supreme Court to rewrite its view of the First Amendment. What is at risk about libel law is something else. We're having more libel suits now than we did at any time in recent years. There was a time just a few years ago in which friends of mine who worked for big media companies and did libel work had nothing to do, and a few of them were fired, because there were no libel suits. The New York Times had no libel suits for years. Time magazine, when it was a much more prosperous institution, had no libel suits for years. Large institutions, big companies that ran broadcast stations didn't have libel suits. And now they're starting to have them again. Now you may have read, Gawker is out of business. The case involved publication of a sexual encounter of Hulk Hogan and the wife of a friend of his. But what's important about that case is that it was all funded by Peter Thiel, a billionaire who was angry at Gawker for revealing that he was gay. And he funded the whole case, and it wound up with Gawker out of business. We have a big case which was just settled in South Dakota against ABC about its report on supposed pink slime that you might have read about or heard about, where a company brought an action, was just settled for $181 million that ABC is paying, possibly plus its own insurance. I have no idea on that, but the public disclosure was $181 million, which is a very large amount of money. We have HBO and John Oliver being sued in West Virginia by the head of the Murray Coal Company for a piece that some of you may have seen, where HBO tried to get the case from state court to federal court in West Virginia and failed. So it's back in state court in front of judges and jurors who might be unsympathetic to Oliver's Northeastern or English approach to a commentary. And all that's really kind of new, is to have just a bunch of new large libel actions against large institutions and smaller ones, which are very threatening. Now, if you add to that a number of the things that the president has been saying, which I think are serious, the libel one I think is not, but he's made comments about everything from confidential sources of journalists shouldn't be protected, to telling the head of the FBI that really be a good idea to put some journalists in jail for reporting classified information, to saying that reporters were the enemy of the public. I mean, to me, this is the stuff of Juan Perón. This is Erdogan speaking in Turkey about the press of that country. And I think it has impact. The president has First Amendment rights too, by the way, but it doesn't mean you can't criticize them. It has impact in terms of the public reaction, of course, to the press. More important, the legitimacy of the press as it's viewed by the public in doing its job, even when they do it well. Finally, I would say my biggest concern about where the administration might go is in the area of the espionage law. We have an Espionage Act, which is 100 years old this year. It was enacted during World War I. It's phrased very broadly, very vaguely. On its face, you could read it as making it criminal for a newspaper to publish information, quote, relating to the national defense, unquote, which they were not authorized to obtain, which is at least half of what our newspapers publish about national defense, about the intelligence, about the State Department, about what the government is doing in all aspects of its work. I think the press has a strong argument, if any such action were brought against it, that you shouldn't read the law that way. But we don't know the answer to that. And there comes a time when the administration, not just the president, is angry enough at the press for publishing information which they think is embarrassing and is classified. We may yet see, as I hope we don't, an effort to use this 100-year-old Espionage Act together. Finally, then, just to come back to this, it's an outrage to be in a situation in which people who have political views, left or right, and want to express it and have a permit, if they need it, in a public area, to be shut down effectively by another group because they disagree with or think that the group speaking is bad, foolhardy, dangerous, whatever. I mean, there's nothing clearer about the First Amendment than that we don't allow what we call a heckler's veto, a veto by people who are angry at someone else speaking and saying things they don't want being said. And that's true on college campuses, to the extent that they're public universities, and on college campuses if they say they're going to abide by First Amendment rules, but it's true in cities and communities around the country. We have enough trouble in this country of people not getting along. The idea that we should have a situation, again, the headline here is as if it's a baseball game. Masked anarchists rout right-wingers. I mean, that sort of routing is something which is at war with the First Amendment. And it's something which should not occur and should not be permitted to occur. That said, shall I sit?
Please.
Okay, thank you all.
Since you brought up the Espionage Act, I wanted to start with a question I hadn't expected to ask you, having to do with the rash of Espionage Act prosecutions under Bush and Obama. It struck me, I was just sort of wondering about your observations with respect to the First Amendment. It's interesting how the press gets on its hind legs in defense, which I agree with, in defense of its right to publish secrets. And yet, it says nothing about the right of the sources that it uses to provide it with those secrets. And the logic here is that if it's publicly significant information that the press is properly making public, why should the people responsible for the provision of that information be punished particularly as harshly as some have been? And I wonder whether there might not be a way to look at the First Amendment's protections as safeguarding their rights to talk.
I don't think there is, and I'm confident the courts don't think there is, a First Amendment right to leak information which you obtain by virtue of having a position within the government. You may serve the public by doing so, and sometimes indeed you would serve the public by doing so. You may be a whistleblower, which is a friendly way of saying someone who has leaked information. Sometimes it really is whistleblowing. Sometimes it's not. I mean, look, I don't think that Edward Snowden, when he provided documents revealing that the U.S. was listening to telephone conversations of the then president of Russia, or that the U.S. and Sweden and Norway had a secret treaty to gather information about Russia, which they shared with each other. The U.S. via planes gathering information, the Scandinavian countries gathering it in other ways. I don't think he served the country by making that information available. More important, in response to your question, I don't think he had a First Amendment right to do so. Now, did the press organizations to whom he gave the information, which is, of course, the only way that I would know of it, have a right to publish it? Yeah, I think there is a difference between their role and his, because they never had a relationship with the government as employer, employee, or otherwise, which at least I think ought to make the basic rule is that the leaking the information is not legally protected. But that is something that people disagree on, what I just said. People disagree, and so someone, Professor Jeffrey Stone at the University of Chicago, would take precisely the other view, and has, coming much closer to saying that the role of the press and the role of the leaker ought to be viewed as pretty much the same. I just don't think so.
Well, I mean, having successfully defended the New York Times' right to publish the Pentagon Papers, we then set the stage for Ellsberg to be tried, and had it gone to trial, possibly convicted of espionage. That feels inconsistent. It feels as if one set of freedoms is being defended and another is being basically accorded less than constitutional significance.
Well, I don't think it is inconsistent. And I think that Ellsberg had a different role. I don't mean that we shouldn't praise some of the people who provide information to the press, but I think they start in a different position, have different obligations, which they should consider, and that in any event, I think it's constitutional to say, as I'm confident the courts would say, that a government employee who has information which he obtained, he or she, as a result of the job that he or she has in the government, does not have a constitutional right to reveal it.
Let me take you to your book. It is, by the way, an excellent book, and I strongly recommend it. I learned a lot from it, and there were a lot of things in there that I had difficulty disagreeing with, even though I still disagree with them. But it was hard. It was hard because I've had some familiarity with your career, admirably. It's hard to miss a rueful undertone in this book, a sense of abandonment that liberals have turned against the expressive freedoms of the First Amendment, and that now, instead of going on a champion in the New York Times, the anti-war left, you're representing Standard & Poor's, cigarette makers, and the U.S. Chamber of Commerce. Do they truly constitute the frontier of First Amendment jurisprudence? Or do they simply command the resources to insist that their claims be paid attention to? And how do you feel now when your people who were once your friends are now moving away from you at the bar?
Well, I'm glad
I meant the drinking bar, not the legal bar.
Yeah, right. First, I'm glad to say it hasn't happened that much, but maybe they haven't read the book, so who knows? Look, we all try to say what we think when we're asked about things, and if people disagree, they disagree. I don't think the press is the only entity that has First Amendment rights. And I think too often journalists think that the First Amendment or the whole Bill of Rights exists just to protect them. So while there are some harder examples in what you raise, I think people should remember that the First Amendment protects the ACLU and the NRA, and the First Amendment protects public libraries, and it protects universities. All of these are corporations, by the way. And that it protects and has been held to protect for years, even for-profit corporations, generally, when they speak out on public issues to the same degree as the press itself. The last thing I said is more controversial in the law, but there are cases before Citizens United, many cases, which have said that. So yeah, I guess my views have changed some since I've been doing somewhat less work for the press and some legal work for other entities. But it certainly never occurred to me when I was representing the Brooklyn Museum in a case brought by Mayor Giuliani of New York to close the museum down because they had a picture that he thought was sacrilegious on the walls. I never thought that a First Amendment-oriented person wouldn't get right away that that's a serious First Amendment case where the punishment sought was because of the content of what the museum had on its walls. Some cases are farther away. We were talking to each other earlier. I mentioned I represented Barnes & Noble at a time when Ken Starr was investigating President Clinton. And there was a subpoena issued to Barnes & Noble in which the investigators were trying to find out what book Monica Lewinsky might have bought to give to President Clinton. And we took the position that Barnes & Noble was entitled to a First Amendment right not to disclose the people to whom it sells books. And all the more so in a situation in which the book was wanted because of the content of it. Again, there are situations in which the competing interests differ from the examples I've given you. And some of them do involve purely commercial institutions, where the question is harder in some cases. Should we protect purely commercial speech to the same degree as we protect political speech? Which so far the answer has been no. We don't give it the same level of legal protection. But I feel strongly that whatever the institution is that's involved in political speech, it should get the same very high level of legal protection. Yeah.
I have some interesting questions from the audience here. I'm not sure what to make. Is an armed parade of neo-Nazis carrying assault rifles in the purported exercise of open carry and Second Amendment rights protected speech on a topic of public importance, or is it intimidation and even insurrection?
Next question.
I didn't see
now,
that one.
That's a very hard and very important and very current question. It's one I've been talking to the ACLU about as they decide sort of on their policy about it. The question I've been talking about is more, when should the ACLU represent an organization in circumstances like that? But as the questioner asked it, as to whether it should be protected, it probably, let's leave me out of it. I believe the courts would say that it probably is protected except in circumstances in which the weapons were used or brandished about in a particularly threatening way. But the mere holding of the weapons, particularly as the questioner quite rightly imported into the question, particularly in situations either A, in which a law allows open carry, or B, the courts wind up saying there's a Second Amendment right to engage, what the courts have not said yet, that there's a Second Amendment right to carry weapons openly. If that's where we're going on the Second Amendment front, I think the courts will wind up saying, yes, you can carry or have the weapons, subject to not intimidating people, not merely by the fact of the weapon, but how it is brandished, used, or perhaps threatened. A very hard and very important and very current question.
I want to take you back to Citizens United and a question from the audience that Citizens United gave voice to corporations and institutions in a disproportionate way, permitting them to unleash propaganda in unprecedented quantity and frequency to the broad masses. Let me turn that in a slightly different direction. When we talk about the marketplace of ideas, which obviously is a metaphor, it's nevertheless, it can be an illuminating one. We're used to restrictions on marketplace behavior to prevent disproportionate and excessive power from being exercised in that marketplace in a way that disadvantages the public, disadvantages the economy, skews the economy in ways that are harmful. And why would we not be interested in fashioning rules that would prevent that kind of disproportionality and that kind of overwhelming power being exercised in the world of ideas?
Because we don't trust the government to make those decisions. Because the core meaning of the First Amendment is that the government cannot get too close to religion, speech, or press, or assembly. That's what it's about more than anything else. That's what it's about. And so for the government to engage in a process of deciding how much speech, as opposed to how much calcium you can put into some product, seems to me entirely different by its nature.
We had audience caps on broadcast ownership, for example. for many years. They've been subverted now under the Trump administration. The Sinclair case we talked about earlier is 72% now. It used to be 39%, where audience caps, the number of people, the proportion of the population that a single corporation could reach through its broadcast licenses, were they unconstitutional?
Well, I think so. And I certainly think you would agree if we were talking about newspapers. I mean, we used to live in a country where most people got their information from the one newspaper in their community, and that was the place in which it was to be found, for better or worse. That's where it was. And we built up a body of law, which I think is well-deserved, but was not controversial when it came out, when, for example, Alabama, back circa 1960, when most news there was in one newspaper towns, gathered by people, they passed a law saying on election day, only on election day, a newspaper could not put a new charge against an opponent in an election, something brand new, which there'd be no opportunity to answer fully. So on election day only, the statute said, you couldn't publish it. And the Supreme Court unanimously said, wait a minute, we don't tell newspapers what to print. That's the answer. That's the whole answer. There are always good reasons. It wouldn't be good if somebody's too powerful here or too false there or may mislead the public or the like. We don't start down the road of saying newspapers can't say things about elections, no less, because of any of the competing factors, and there are competing factors.
I'm curious why you think the vigor of First Amendment kind of jurisprudence has shifted over the last 20 years. The initiative is coming so often from the right. And it's something you noticed earlier in the century with speech codes and campus free speech, which claims its birth at the University of California, Berkeley, which then was strongly identified with liberals. And now suddenly it was liberals who were the target, who were thought to be, were held up as being the people who were responsible for suppressing free speech. And there seems to be a consistency. The First Amendment seems far more friendly. The right wing has discovered the First Amendment as an instrument in ways that they long resisted. And I'm just wondering, and I'm not to get to the merits of the particular cases, but I'm wondering what has happened to the zeitgeist where now the First Amendment has been appropriated by the right?
Well, one of the things that's happened is that the left has won a lot of the great battles that have been fought in the last 20, 30, 40 years. On university campuses, we do not lack for progressive professors. So there's, if the left is upset on campuses, it's usually not because of something the university is doing, but something that American society is doing, of which they disapprove. Whereas, apropos yesterday, but not just in Berkeley, the people who tend to be shut down on campuses these days tend to be of the right. I mean, the right or the center, but more often the right. So we have both sort of right-wing kooks being, in effect, have their speech suppressed, or people that, very militant people on the left, to pick a few names, the head of the International Monetary Fund couldn't give a speech at Wellesley because she was shut down. Condoleezza Rice had to withdraw from speaking at one university. I mean, one example after another. Ray Kelly, police commissioner of New York, shouted down at Brown. The Israeli mayor of Jerusalem shouted down at San Francisco State. I mean, the shouters in this world have tended to be on the left and generally on the pretty far left. And so, yes, the conservatives have found the First Amendment. And they're entitled, they're fully entitled to the same level of First Amendment protection. Do I have to say this? As would be the case if they were of the left.
What do you tell your students now, then, about what the limits should be of white supremacist expression, of hate speech, of speech that identifies, targets, stigmatizes? These are the kinds of questions raised now on campuses. The morning after the Trump election, at a town hall meeting, students, and it was hard not to be touched and moved by the degree of exposure and vulnerability they were expressing. If they were non-white, non-male, non-US born, non-straight, they thought that their enemies had been enshrined in power. And they are, and I'm not arguing that anybody should be muzzled, but I'm saying that the antidote to bad speech is good speech is a soothing notion, one that you and I subscribe to, but it's not necessarily a very comforting one.
No, it's not. And they, in my view, they were and are right to be concerned, and right to be very concerned, in fact. I don't think there is a soothing answer, or an honest, soothing answer that can be given them. All you can give them is the notion that people in opposition, people in the resistance, as it were, have to band together, and they have to keep doing all they can to change the situation from what it is or may be, from what is at least understandably threatening to them, to one in which it's not so. Also, to get a level of reassurance from, if they're in college, that they'll be protected by their college, by their university, that people who matter, who have power, will stand with them and try to protect them.
I know that, as you pointed out, and as I think we all know, the First Amendment does not tie the hands of private players and private speakers. They are not, and it doesn't keep private players from restraining expression as well, among their employees. I'm wondering, though, that how you feel, not so much as a lawyer, but as a citizen, about the threats to expressive freedom that seem to come not from government, but from exceptionally powerful private companies, the ones who control the overwhelming flow of information on the internet, that are answerable to no one, that have no intelligible codes. We don't know what criteria they're using, and they are immensely influential and powerful. Now, what should we be doing, be thinking about, that might take the form of laws? It might be the way collective action expresses itself, some sort of laws, and you can be sure they will claim First Amendment protection to do whatever it is they're already doing. Yeah. What's the answer?
It's a hard question. Let me give the easy part of the answer first. Why is it a hard question? Once you're in the speech area, there are great limits on what the government can do, and I would say what we would want the government to be able to do. There are potential remedies legally down the road, maybe someday, on the antitrust laws or future laws which deal with the amount of power that this company or that company has. That's one road. The other is the these companies are deeply, deeply aware of and enormously interested in public reaction to their behavior. They're dependent on public support, and more than anyone, they know where the public is in this moment or that moment. So the way this issue comes up more often than not is when we ask a somewhat different question. What do we want Facebook to do, or Google? What policies would we, if they asked you, do you think we should ban racist speech? Do you think we should bar Der Stürmer or whatever that right-wing publication is, that racist publication, which now has been dropped by some of the largest entities? The First Amendment protects it all, every bit of it. It's non-negotiable, and it's not a hard case. The question of what we want the Facebooks of the world to do is what I think is the really, really hard question, which I've been, for whatever it means, thinking about for some time. Because, for example, yeah, I think it's a good idea for them to have some sort of policy and try to enforce it about racist speech. They don't have to carry it. First Amendment doesn't require it. They have legal issues about becoming editors and maybe losing certain legal benefits. That's not my problem. That's their problem. So we come back again, as I view it, to the same policy question. Do we want them to play the role of editor? And if so, when? And my reaction is we do. That we want them to have some policies, not to publish terrorism supportive and revealing and helpful information of some sort. Not because the government tells them they can't, but because it's dangerous. And because it's racist to have certain types of material published. But let me say, as I say that, we have to understand what we're buying once we say that's what we want from them. We are saying precisely what you were, by your question, warning against. These all-powerful, private, non-responsible to anything other than their own views of profitability or responsibility, whatever it may be. But unencumbered by almost any obligations except what they choose to take. That do we really want them to say, I'm not going to carry that publication, it's too far to the left, or that's really offensive because it's too sexually oriented or not. All in the area of speech which is protected by the First Amendment. So, yeah, my answer is if they want to put child pornography on, which would be illegal anyway, but that they want to put on certain types of material which are protected by the First Amendment, but which are deeply offensive and harmful, I'd rather that they didn't. Just as I would call my local newspaper and say, you don't have to do that. Why are you doing that? You don't have to take that ad. You don't, so that's why this is a very, very difficult area and a very important one, because these policies are not set in stone of these institutions. They are working on this because they are under great pressure all the time from all sorts of bodies, including government bodies. Wait till we have the first terrorist act, and the terrorist said, I read it on the internet. I learned how to do it. They've had them in Europe more than here. Perhaps some here also. And then the question is, well, what is it that you don't want us to carry? And I'm not saying there's no answer to that. I'm just saying these are really hard questions of what it is we would urge them. If you were sitting, if it weren't me, if it were the guy that runs Google and the guy that runs Facebook, et cetera, and they said, well, tell us, what policy do you want us to have? I'm just taking the easy way out for the moment of saying that's a very hard question. And I'd be very interested, we can't do it today, but to hear your answers and those of the general public.
I agree. They're hard questions. What I'm stumbling over is the question you asked, well, what do we want? What I despair of is losing the space within which that question can even be posed.
Right.
And the people in control of the space through which that discourse takes place have a vested interest in having the outcome of the discourse.
That's true. I saw a little bit of this. This is not a great personal story, but I represented the Motion Picture Association in an effort to persuade members of the Senate Judiciary Committee to pass certain legislation designed at protecting their copyrights against the movies being lifted, basically stolen, and shown on the internet. There were different forms of legislation which are being considered. What the Judiciary Committee came up with was something which would have required the Facebooks and the Googles and the like, once being told of copyright violation, being accused, to have to check it out and do this and do that. The Senate Judiciary Committee had unanimously been in favor of this legislation. Google, Facebook, Microsoft, and the other largest institutions all went dark for a few minutes in protest against this legislation.
Right.
And they took out ads in the newspapers, but going dark. And the senators, and I really was there, the senators were inundated with letters in amounts they had never received before on any other subject about this very complicated copyright piece of legislation where though and I'm talking a few years ago now, to pick a number, 8 years ago, something, where so many people were so invested in the freedom of the internet as they viewed it and as the owners of these entities urged on them, that Congress dissolved in about half a day. Senators who had voted in favor of this legislation denounced it. And it went away very, very quickly. So, I mean, the entities that you're speaking about are, enormously powerful. But one of the reasons they're powerful is that they're very popular. I mean, it's not that people go around, with banners for Facebook, but Facebook serves a need, a utility. It plays a very important role in the lives of so many people that on the one hand, they really do care a lot about what their subscribers think and want, but they're also enormously powerful. And particularly when they all get together, they're all but unstoppable.
I mean, it seems to me, though...
There is no legislation.
Well, I think going back to your question, what is it that we want? It's clear after the last election that we don't want fake news, that news sites that are propagating information that is demonstrably false and it can be labeled as false, can be identified as false, should not be disseminated. And they have the mechanisms, they have the means to identify that, they have the means to embargo that, and they did not, possibly because they were making money from it, but possibly because they didn't want to acknowledge they have editorial control over their own systems. But I mean, where does this groundswell of popular sentiment manifest itself?
Well, I mean, sometimes it manifests itself simply by people subscribing. to one or another service, or choosing to do so. But we haven't had a situation yet. The situation I described was so minor league that it was all the more startling to everyone that suddenly the world came to an end. So if you're talking about big time limitations on what they can do, that will take a major change of the public mind.
Well, thank you. Our thanks to Floyd Abrams, noted attorney, constitutional law scholar, author of the new book, The Soul of the First Amendment. We also thank our audiences here and on radio, television, and the internet. A reminder to our audience that Mr. Abrams' book is for sale. He'll be signing copies following the program. I'm Ed Wasserman, Dean of the Graduate School of Journalism at the University of California, Berkeley. And now, this meeting of the Commonwealth Club of California, the place where you're in the know, is adjourned.